It's my great honor and privilege to introduce to you one of the most rising and upcoming lawyers in America. I want you to know he's Josh Hayes, straight from Tuscaloosa, Alabama, by way of, I will mention Boaz. He is the third child of Mr. and Mrs. Hoyle Hayes, who happen to be with us tonight. You can figure out who his daddy is. He's that big guy over here on the left. But and that's his mama right beside him. But we're so glad to have Josh with us here tonight, and he's going to talk to us about tort law, which is a subject that he is an expert in. He and his law firm have set all kind of record verdicts down in Birmingham and the Tuscaloosa area. They practice out of Tuscaloosa. He, by the way, graduated cum laude from the University of Alabama in accounting and was one of those men who was a member of the ODK, the Jasons, all the honorable things you can do. He was the most outstanding senior when he graduated. And thereafter, he worked for the governor and was one of the youngest people to serve on the governor's cabinet. And since that time, he has done an amazing job. I'm real proud to know him. I want you to know he and his wife, Carrie Ann, who is a registered nurse, are very active in the Tuscaloosa community. They're members of the First United Methodist Church there in Tuscaloosa. And I want you to know he also married well, because Carrie Ann's father is a circuit judge down in that area. And it always helps to be the son-in-law of Judge Bentley. And so that hasn't hurt him, but his skill and expertise in the area precedes him, and I want you to know it is a great privilege to have him here tonight. Josh Hayes.
Thank you
so much.
Thank you, Alan. Good evening. It's good to be with you all again. This is one of the highlights of my early winter months. My firm and I always come up here to the People's Law School in January through March. Some of us at different times. I think next week my partner Matt Glover will be here, and later on in the early spring Bobby Prince will be here. We are all very thrilled to be part of the faculty at the People's Law School. It's our privilege and honor to kind of give back a little bit. The community has been so good to us, and we feel like this is the least we could do, is to kind of tell about some of the work that we do on behalf of the citizens of our state, and also educate people along the way. And so we're always glad to be here. So tort law, that's the topic tonight. Who knows what a tort is? A wrong, all right. That's very true. And let me say before we get started in earnest, we'll take some questions at the end, but feel free to interrupt me along the way. Raise your hand and we'll repeat the question so the viewing audience at home can hear, but interrupt me if I say anything that piques your interest. So a tort is a civil wrong. That's basically it. It is something, as the screen there says, it's damage done by a wrongful act to either a person or somebody's land. That's basically what it is. And so let me ask you a question. Is a tort the same thing as a crime? Any answers? No. All right, no is the right answer. Now there are some similarities. The two go hand in hand. They overlap some. There are some differences. So what are some of the differences? Well, for one thing, the burden of proof is different. In a criminal case, you've all heard maybe on TV lawyers stand up and say that their job is to prove to you something beyond a reasonable doubt, right? You've heard that standard. That is not true in a civil case. Civil case, a lesser burden, and basically the legal definition for the burden is a preponderance of the evidence. Well, what does that mean? Basically it means more likely than not. And in fact, some lawyers will say, think about the scales of justice, and if it's tweaked ever so slightly in one way, then the lawyer has met his burden, his or her burden, that they have convinced you more likely than not. And that's the burden. There's also another difference between crimes and torts in that the punishments are different. So we all know if you're convicted of a crime in Alabama, a felony, you can go to jail. The punishment is anything from death penalty in a capital murder case, but the least you can be punished in a felony case is a year and a day in state prison. A misdemeanor, a year in a county jail. And fines and restitution. Those are all things that can be a part of a crime. Well, in a civil case, and I'm a civil lawyer, I represent mostly plaintiffs, but a few defendants in civil court. and they are either making a claim for money damages or defending a claim for money damages. And the worst thing that can happen to you in a civil case is you can be found liable. Okay, you're not found guilty, that's for criminal court. You're found liable, and the jury assesses damages against you. Right? So my partner Bobby Prince, who you're going to hear from later, has handled a variety of cases over the years, including capital murder cases. And he says once you handle one of those, what's the big deal? Somebody might owe you some money, right? So that is the difference, and that's a very real difference in Alabama. Okay, and we talked about the term liable. In civil court, you're not found guilty. You're found either liable or not liable. And in criminal court, of course, you're either not guilty, and that's different from innocent, isn't it? We all recognize that. Not guilty or guilty. All right? So can any of you think of an example where maybe a person has been found not guilty in criminal court, but has been found liable of the same action?
OJ.
All right. That's a look. You read my mind. So O.J. Simpson, right? So we all remember this scene. If it doesn't fit, you must acquit, right? Johnny Cochran said that, and that, of course, is the best example that I can think of and that you can think of. The jury in that case did not believe that the prosecution proved their case beyond a reasonable doubt. That's a standard. But several years later, in the wrongful death civil case, the plaintiff's lawyers were able to convince that jury that by preponderance of evidence, he was guilty or liable for wrongful death. Okay, so let's talk about some torts. I'm going to spend some time talking about various ones tonight. There are some torts that are intentional in nature. We're going to talk about negligence in a little bit. That's really the most common tort. That's a car wreck. That's a product that goes bad and hurts somebody. But before we get to there, we're going to talk about some intentional torts. And that obviously has a state of mind that the person intended to do it. They did it on purpose. So there are intentional torts to the person, and there are intentional torts to land. Intentional torts to the person, battery. Basically what a battery means, and sometimes it goes hand in hand with assault. You've heard of assault and battery. Really, they're two different torts. An assault, we'll start there, is a threat to do harm. That is what an assault is. A battery is if the person makes good on that threat. It is basically, some lawyers refer to it as the assault fulfilled. That's the battery. So assault would be a threat to punch somebody in the face. The battery part would be actually punching somebody in the face. Sometimes those go hand in hand and sometimes they're separate. False imprisonment is just what it says. It's holding another person against his or her will. We have had some cases like that in the not too distant past. My firm handled a case, a terrible case, where a truck driver picked up a young lady at a truck stop and held her against her will for months. And you can imagine how that went. And so we were able to sue him individually and hold him accountable for his actions, but also we proved by preponderance of evidence that his company should have known had they been keeping up with him and had they looked into his background, then that probably would have never happened. Also on the screen there is a tort called intentional infliction of emotional distress. That's a bunch of lawyer words that means you really acted badly. That's what that means. Outrage is also what it's called. The Alabama Supreme Court only recognizes the tort of outrage in Alabama in a very limited number of circumstances. Some states have more examples of outrage, but Alabama only recognizes it in a handful of situations. One situation is in a workers' comp situation where the doctor says that a patient needs a surgery, but the workers' comp adjuster says, oh no, we can't afford that. Okay, now that is egregious conduct. I think we can all agree. That's some insurance adjuster just trying to save her company dollars. The courts have said that's outrageous conduct. We can hold you responsible for that. Another situation where outrage can come into play is anything to do with a dead body. Okay, so if your mama dies, the funeral home mishandles the body, that can be an outrageous situation. I think we can all see why. So there are very limited circumstances in Alabama where intentional infliction of emotional distress can go to a jury. All right? Now, there are also some intentional torts to property. Trespass, I think we all know what that is. The law makes a difference between a trespasser and a mere trespasser. Any ideas the difference? A mere trespasser is somebody who really doesn't intend, even though it's an intentional tort, doesn't intend to do harm to the property. Maybe stumbles upon somebody's property without knowing where he is, doesn't intend to do any malice or damage to the property. There's a difference there than somebody just trespassing onto land to wrongfully hunt on someone else's property, or there are a variety of other examples, but trespass is a tort, an intentional tort to land. Conversion. Conversion is another type of intentional tort to property, and basically what that means is a person or a company takes something that belongs to you and converts it to the company or the person's own personal benefit, and that's an intentional tort. It can also be a negligent act, but it basically is you taking something that doesn't belong to you and converting it to your own personal use. All right? So, but by and large, most of the tort cases in Alabama are negligence. These photos here show a terrible car wreck that happened 2 years ago. After a football game, we represented the people in this car. A terrible brain injury that happened about 3 in the morning. You can imagine what the other folks had been doing after a football game. The car that ran through the stoplight and caused this injury was owned by a multinational pharmaceutical company. No bad luck for them. Thankfully, they had plenty of insurance, and our client needed every bit of it. 4 elements of negligence, and I thought what we would do for the next few minutes, and remember to stop me anytime, but there are 4 elements that a lawyer has to prove in order to meet his or her burden that a person is guilty or a company is guilty of negligence. We're going to cover those 4, but we're going to cover them in a way that kind of tracks you through an actual case that we settled not too long ago. And so you'll get to see from the plaintiff's lawyer perspective, what it's like to prove each of these 4 elements. All right. So the first one, duty. I think we all have a pretty common sense approach to what a duty is. Duty just means that you have a duty either to do something or a duty not to do something. All right. A common duty might be we all as drivers have a duty to obey the rules of the road. We have a duty to stop where we're supposed to stop. We have a duty not to exceed the speed limit, have a duty not to weave in and out of traffic, those kind of things. And so duty, in this trucking case that we filed in Montgomery County, Alabama, a lot of times in the discovery part of a case, that's where documents are swapped back and forth. You can use a company's own documents against them, and that's what we did in this case. The documents in this case set forth rules that this particular trucking company, a large company out of South Carolina, it set forth rules where they expect their drivers to follow, but even before you get to where a driver is hired, their internal company documents said that drivers have certain minimum standards that they have to meet before they're even eligible for hire, and that's some things we've talked about in years past here. Minimum qualifications. All right, so this trucking company says in Part A there, the driver has to have 1 year's verifiable over-the-road trucking experience in the operation of a tractor trailer. He's got to have driven for another company for at least a year. Accident criteria, there are several things there. The important one to this case is the driver should have no ticketed accident within 2 years before the date of the application. In other words, He can't have caused a wreck and received a citation for the same wreck before the accident, okay? So in that case, that is the duty that the trucking company had. Their own company document set forth the standard by which they're supposed to hire drivers. That was the duty. That became the law of the case. They agreed to it. We didn't make the document. They made the document. They were bound by that document, okay? So the question became in this case, like many cases, was the duty breached? Now, keep in mind that we had sent out 20 or 30 subpoenas before the deposition that you're about to see of the company's safety director. We had the driver's full driving record, and so we knew from looking at that driving record, just on the face of it, when you compare that driving record to the internal company document, that they had a breach of the duty. So you tell me, just based on this testimony, do you believe that we met the requirement of breach of duty?
Take a look at events 5 and 6.
Yes.
10/14/2006 would have been about a year and a half, maybe a little less, before he was hired. And it looks like he was involved in a crash, and the same crash resulted in a citation.
Correct.
Based on that, should he have been hired by?
No.
All right, so pretty straightforward. Your company document says this, he did that, should you have hired him? And for once we got an honest answer. He admitted, no, we should not have hired him. Okay, so I believe you would agree. The second element that we had to prove to get this case to a jury, breach of duty, occurred. All right, now causation. Causation just means what you think it might. It means that the breach actually caused the harm. All right, it can't have been so remote that a breach in a minor thing that didn't matter to the actual injury. I mean, you can't play a gotcha kind of game. It's got to be a substantive breach of a duty that goes into causation. Those two things are related, that actually causes the damage. And so in this case, we hired an accident reconstructionist. This happened in downtown Montgomery, basically at the intersection of I-85 and I-65. You've all been there, I'm sure, or a lot of you have. Right in front of Jackson Hospital, and this was a rear-end collision. Our expert went out to the scene shortly after it happened. He mapped the scene, he tested the roadway, he measured the skid marks, he measured the crash information between the two commercial vehicles. Our client was driving a commercial vehicle too. He determined that this wreck happened between 47 and 51 miles an hour. That is the speed the 18-wheeler was going at the point of impact. That's not a little tap. That's going pretty good. Now, he was going a lot faster than that before he ultimately slowed down a little bit. This expert, Bill Messerschmidt out of Birmingham, who we use a lot in cases, and by the way, he's also hired a lot by trucking companies. So sometimes you can get experts who will say anything. That really does you no good. We don't ever want to put up an expert where they say 100% of the time I always work for plaintiffs, right? Because the credibility kind of goes through the floor there. So Bill Messerschmidt also measured the response time of this driver. And as you can see there in number 2, that bullet point 2, it took this driver about 3 times longer than it should have had he been paying attention to figure out that a wreck situation was about to happen. So he was going to be in a wreck anyway, most likely, because there was a backup in traffic. But because he was speeding and because he wasn't paying attention, he ran into the back of our client, causing some pretty serious injuries that we'll talk about in a little bit. His third conclusion there was if this tractor trailer had been going the speed limit, he wouldn't have even been in the area, okay? Now that's pretty good on causation. Would you agree with that? If you're not even in the area, then you can't have caused the damage. And so flip side of that, because he was where he was and where he shouldn't have been had he been following the speed limit, then he directly caused this wreck. All right, so the third element there, causation. And you see, if you take it in bite-sized steps, and that's, by the way, what a jury likes, keep it simple. I think we had a president that said that, right? Just keep it simple, stupid. That's what jurors like. They want you, they don't want you to demean them and make it too simple, but you need to put it out there for them so they can easily follow along. And so causation was met. All right, now we're going to come back to damages in a minute, but before we talk about damages, let's talk about some common defenses to negligence. Now's a good time when we're talking about the causation element is, are there some defenses to negligence? There are. Even if you are guilty of negligence, if the plaintiff is guilty of either contributory negligence or assumption of the risk, then the law in Alabama is that plaintiff cannot recover. Zero. That's pretty harsh, but that's the law. Now, jurors don't always follow that law, but that is the law. And so some examples of contributory negligence. Standing on a ladder on the very top rung. Clearly, there are warning stickers that say, do not go above this line. If you do, you're probably going to be hurt and we're not responsible for it. That's an example. Another example is seatbelt use. And I put this up here. It's a little bit of a trick because there's some law in Alabama that says that just because a driver is not wearing his seatbelt, that is not evidence of contributory negligence. Now, a lot of people think it should be. If I leave here tonight, I'm not wearing my seatbelt, I'm in a wreck, and I'm injured, should I be able to make a claim against you if you cause it? Well, the law says that the jury never even gets to hear that I wasn't wearing my seatbelt. That's the law. It's kind of a surprise, but that is the current law. All right. This is something I would never do. I don't know if any of you would. Bungee jumping off a bridge over a river. I'm sure he's got a good view. I don't think I'd survive. Heart attack would set in, but that is an example of assuming the risk. I guarantee before this fella strapped the bungee cord onto his ankles and jumped off, he signed something, don't you think? He signed a release that said, I am assuming the risk of my behavior. And if I get hurt, I'm not going to sue you. You see that a lot of times in you know, if you're renting some equipment, you're in a city and you rent a moped, for example, or you rent some ski gear and something goes wrong, you have probably assumed the risk by signing that paper. Now those clauses can sometimes get thrown out, but that's the general idea, assuming the risk. One more here. Some people, keeping with our outdoor theme, there have been people that hurt over the years in ski lifts. And the case law is kind of split on this. When we get on a ski lift, have the idea that it's going to work like it should, right? Or you wouldn't get on it to begin with. Some courts have said, well, they did not assume the risk because they assumed that the ski lift was safe. Other courts have said, no, just because it's a dangerous type activity, you did assume the risk and you cannot sue. So sometimes the same courts in different states or different venues reach different results. That's frustrating from a lawyer's perspective, I can tell you. And it's frustrating from a litigant's perspective, somebody who's in court. We want, as a system of justice, for there to be uniform results. But I can tell you, just from firsthand experience, that your case, if you're injured in a car wreck, is worth less in Madison County than it is in Jefferson County. That's a fact, and Alan would back me up on that. Some venues have a propensity to return higher awards than others. Madison County is a conservative place, right? Conservative jurors don't return high awards, and so judges are elected by those conservative jurors. Sometimes judges make rulings that are really, if it had happened somewhere else, they might have reached a different ruling. That's frustrating from a lawyer's point of view. All right, so sure enough, back to our trucking case in Montgomery. This is our driver. He remains nameless. As part of the agreement with the insurance company when we settled, this was his version of how it happened, and it clearly lays blame on my client. Even though he was hit in the rear, even though he did nothing wrong, and there were numerous witnesses that said that. From the very beginning, this truck driver and this trucking company sought to make my client guilty of contributory negligence. And I'm going to show you the law so you can read it for yourself in a minute. It's harsh. If they were able to convince a judge or a jury of this, we would not have been able to recover $1 for our client who had 2 surgeries and is never going to be able to work again. That's a harsh rule. If you're 1% at fault, you cannot recover. All right, so sure enough, this truck driver says that our client passed him on the right, cut over in front of him, and slammed on the brakes. And he said not only did that happen, there were numerous witnesses on the scene. I've been telling the same story all along. People will back me up on this. I told the police officer the same thing, and so if you talk to him, if you take his deposition, he's going to tell you the same thing. That is the story they began telling from the beginning of the case. All right, so here is the law that I was telling you about. But first, let me tell you what this is. This piece of writing here is called a jury instruction or a jury charge. And part of the process when a lawsuit is about over, you're at trial, the lawyers have just given their closing arguments. Right before the jury goes back into the jury room and deliberates, the judge reads a series of jury instructions, jury charges, some people call them. This is the charge on contributory negligence in Alabama. Defendant says that the plaintiff's conduct was negligent and that it was the cause of his or her harm. To prove this defense, the defendant must prove to your reasonable satisfaction all of the following. Number 1, the plaintiff was negligent, and number 2, that negligence was the cause of his injury. And then the judge goes on to say, and this is a really fatal language for the plaintiff, if the plaintiff's conduct was contributory negligence, he or she cannot recover on his or her claim that the defendant was negligent. That's powerful. And the judge says that not only once, it comes up in other jury charges too. The jury hears that. And if, because good defense lawyers know that a judge is going to say that, they get up in their closing argument and say, the judge is going to tell you that if Mr. Smith is 1% at fault, you cannot award him any damages. How many of you think that's fair? Anybody? All right, we are one of 2 states that still has that rule. Most states have something called comparative negligence. We've probably talked about that before here too. And it's just what it means. The jury decides how much the plaintiff is injured. And remember, in a civil system, all we have to do is award damages, money damages. And so that's what the system is. And so the juror comes up and says, say $100,000. That's how much you were damaged, Mr. Plaintiff. But we believe that you were 20% at fault, and therefore we're going to reduce your damages 20%, and you now get $80,000. Yes, ma'am. We got our first question.
Not wearing a seatbelt would not count towards the 1%.
All right. The question is a good one. Not wearing a seatbelt, would that not count toward the 1%? The law in Alabama is a jury cannot learn that the plaintiff didn't wear the seatbelt. So no. That may change over time. Laws do change over time. Every Friday, the Alabama Supreme Court and our appellate courts issue opinions. And I read those opinions, and a lot of lawyers do every Friday or over the weekend. And I keep waiting for the case where our judges say, well, that's a bad law. We're going to fix that. But so far, the law is they do not get to consider that. Yes, sir.
You mentioned earlier that we were talking about what's a criminal and what's civil. In like in that O.J. case, the civil, wasn't it brought up that there was certain evidence that could not be brought up in the criminal versus the civil? And so how would that apply in this?
That was part of the yeah, and I'm being reminded to repeat the question. Wasn't the jury in the civil case told that the criminal jury didn't get to hear some of the evidence? Is that basically your question? I believe that did happen, and again, that is more of a function of different judges interpreting rules different ways. And so in the criminal case, I think it was Judge Ito, right? Lance Ito. Numerous sidebars. That's what I remember about that trial. He did not let the jury hear about some things that frustrated the prosecutors. That is nothing unusual. Lawyers get frustrated with judges all the time. But that judge was pretty conservative in what he let the jury hear. And I do believe that in the civil case, that jury got to hear more. And so that made the difference. That plus all the publicity, all right? So the whole world knew about the case. You could not find an impartial jury, I'm sure. And so those lawyers had the benefit of seeing what the state of California did wrong in that trial, plus all the pretrial publicity, jury saturation with knowledge, and they heard some evidence that the criminal jury did not. Sure did. Any other questions? Yes, sir.
So back to what you were talking about.
Right.
You said that, is it in Alabama that you can get the 100,000 to 80,000, or is that other states?
That's other states. The question was, he's asking about the comparative negligence. If you apportioned some of the damages that the jury comes up with and penalize the plaintiff for it, give them a discount for some reason, that is comparative negligence. We do not have that system in Alabama. Now, it may be coming, but currently that is not the law in Alabama.
So, to go back to the case that you just were talking about with this trucker, could somebody say that, well, if you stayed home sick that day, you would have never been on the road? Could that be considered part of your negligence of, you just happen to be there?
The question was, could somebody say if the plaintiff had not even been on the road that day, can that argument be made if you had never been on the road, you wouldn't have been injured and therefore you shouldn't recover? That argument would be a little dangerous for a defense lawyer to make, in my judgment. Lawyers do crazy things all the time, but I think a jury would get mad at a lawyer that suggested that. I think, and believe me, as lawyers, we have to be very careful how we act and what we say in front of a jury. Because there are 24 eyes watching you and your client at all times, and so you got to be very careful. And alienating the jury, suggesting that, if I was on the other side, I'd say, what? It's a free country. I can't get out of my own house because some truck driver might bowl me over. You got to be careful with stuff like that. I don't think that would fly. Yes, sir.
Going back to his question, are there types of evidence that can be in one court and not in the other?
Are there types of evidence that might be admissible in criminal court and not admissible in civil, or vice versa? Not really. Really, the rules of evidence, and there's a book about that thick, the Alabama Rules of Evidence, and pretty much it applies to both courts. Lawyers need to know those rules. And those rules change over time too. There's a committee of judges and lawyers that makes those rules, and sometimes those rules change, but generally the rules are the same. Rules of evidence, while we're on the subject, cover things like hearsay, right? You've all heard of hearsay. Basically, you can't get on the stand and say, Jim told me that this happened, and for that reason I know what happened, all right? That is against the rules. You got to put Jim up there to say that. That protects, the idea is hearsay is unreliable. That's a general idea. Things get changed over time as it's passed along. You might not get the total truth, and so that's an example of a rule of evidence. Any other questions while we're here? Yes, sir.
Unlicensed drivers
Mm-hmm.
involved in an accident like
Right.
this. Is that something that's contributing?
If the plaintiff does not have a valid driver's license, could that be considered contributory negligence? You know, that's a good question. Judges generally would not allow it for that purpose, all right? So they may allow it to come in for another purpose, but really, and see, that kind of gets to the causation argument too. What did the fact that the plaintiff did not have a driver's license have to do with the 18-wheeler hitting him from the rear? Probably nothing. Now, the flip side of that is kind of going back to his question, but if the plaintiff wouldn't have even been on the road that day because he didn't have a license. I mean, I see where you're going with that. I think a judge would probably not let a lawyer make that argument. Again, it's up to interpretation, and sometimes different judges handle things different ways. So, okay. Any other questions while we're here? Yes, sir.
Yes, sir. On the rule of duty, like you said, if the truck driver had applied and he lied on his application and did not admit to having those traffic incidences prior to the 2 years, is the company still at fault? I mean, at what point does the liabilities company, end as far as
Yeah.
applicants being truthful? You can't double check everything.
All right. In summary, he says you can't double check everything, and if, going back to our truck driver in the example, if he lied on his application, which happens all the time, right, because truck drivers need jobs, and so if they list everything, they might not get that job. If they lie on the application, is a trucking company still liable, basically? Is that it? Well, it depends, and that's the legal answer. It depends. It depends on if the company either knew or should have known, and that's the important part, should have known that he was lying. Okay, now there are some companies that trucking companies use to help them qualify drivers. They pay a monthly fee to these big companies, and they help them do background checks. They help check with prior employers. But even if that company messes up, the law is that you can contract that out, but it's still your responsibility. It's called a non-delegable duty. So I can't hide behind one of those companies is called DAC Services. That's the name of one of those companies that does background checks. If I'm a trucking company driver, owner, I cannot hide behind DAC and say they didn't find it, and because that company also has a responsibility. There is a rule, a DOT regulation that says that you have to check with the prior employers of drivers that you hire. And so if they had done that in this case, they would have learned that accident we were talking about happened and he got a ticket, and he would not have been eligible for hire under their own company rules. Good question, though.
What if I got, or have had several tickets? And a reckless driving within a certain period of time? Like within 5 years.
Right.
He drives a semi, so I was asking about that. Can they pull their license?
The question was, if there are multiple violations within a certain time, including a reckless driving, can they pull their license? Yes. Yes. Some states have a point system, and Alabama does too, where if you get over the allotted points, they can revoke or suspend your license. Yes, ma'am.
What was the personal liability of the driver? Did he also have to pay damage?
In this case, the question was, did the driver have to pay damages out of his pocket, or did his insurance company pay damages? No, because he was covered by the trucking company's enormous insurance policy, his own company did not have to pay. Yes, ma'am.
I wonder if the trucker was from Kentucky, but it was coming through Alabama, and you got hit. Which law applies? All
right, that's a great question. If the trucker is from another state, she used Kentucky, and he's coming through Alabama, and the wreck happens here, where can you file the suit, basically, or what? Not the suit, but which law applies? Yeah. The points to his insurance? Yeah. Well, the points reflected in his driver's license, there's a DOT reg that also says that truckers can only have one license. Thank goodness, right? That they can't go from state to state and keep one current and let another one lapse and whatnot. So a commercial driver can only have one CDL, commercial driver's license, and so it would be reported to whatever state that is. So if he gets a ticket in Alabama, the states share that information, and eventually Kentucky would know about it.
But if you're hurt, who's responsible, Alabama or Kentucky, for example?
Well, if it happens like that and an Alabama driver gets hurt by a Kentucky company, you can file in either place. all right? The law of Alabama will apply, though, because there's a theory in tort law that says we want, wherever the injury happened is, we're going to use that law, right? So even if the case was filed in federal court in Kentucky, because the parties were all from different states, that's one way to get it to federal court, Alabama law would still apply. But if the defendant's in Kentucky and the plaintiff's in Alabama, and I'm the plaintiff, I want to be in Alabama, right? Generally. Yes, sir.
Book of evidence, if there's someone admitted in evidence, as evidence in this in black and white, can the judge just say, no, I'm not going to do that, even though it's just perfectly laid out?
The question is, if there's a rule of evidence in black and white and the rule says that something is admitted, can a judge just not go along with that? Well, the judge should not. It happens. It happens. It happens. Let me say this. In Alabama, we are blessed with a great bench. We have a lot of great judges. However, there are some that are not so hot. And so there are judges that get reversed on a pretty routine basis for not following the rules. And that's the remedy. And so from a lawyer's perspective, it stinks, because if it's an important piece of evidence and it comes in and it sways the jury's decision and the judge was wrong, well, you really can't unring that bell. The jury's already heard it. So the remedy is you appeal it to the civil appeals and maybe even in the Supreme Court, and the best you can hope for is a new trial if it doesn't go your way. There is such a thing as harmless error. That's what appellate courts refer to a judge who made a mistake, but it wasn't big enough to sway the outcome. But that's kind of speculative too. There's reversible error, which is what it sounds. They get a new trial, they reverse the judge, and then there's harmless error. And harmless error that will not get you a new trial. So we need to move along here just a minute, and we'll take some more questions at the end. But this is a trucking company story. This was a truck driver's story. He cut in front. And so over the course of this deposition, you're about to hear from the truck driver, we spent all day with him, and it took a while because he did not speak English. And so that's okay in Alabama, and that's okay in America. You do not have to speak English to be a truck driver. Now, some companies require you to. This driver spoke a little English, but not too much, and so the deposition took a while because we had an interpreter. It took place in Texas, and he was a nice enough guy, he just couldn't tell the truth, all right? That's a problem in front of a jury, and after several hours of going through numerous documents where he maybe fudged a little bit here or didn't tell the complete story here or over there, maybe minimized some things, I asked him toward the end of the deposition what he thought a jury would think about some of those untruths.
Not truthful on that application to embark, were you?
No, yo la llené así
No, I
rápido.
just filled it out like that.
All right. And you were not truthful in your written answers to questions that we wrote you earlier in the case. We had talked about interrogatories.
No, pues,
Listen to his question.
Well, no. Escucha.
You agree that you were not truthful in your answers to interrogatories.
sí.
Yes.
So when you were talking about how the wreck happened,
Entonces,
why should a jury believe what you had to say?
Y pienso que estaba diciéndole la verdad lo que pasó. Si lo que no dije aquí,
I think that I was telling you the truth about what happened. If I didn't tell the truth here,
no sé, es lo que yo estaba platicando, no me acuerdo que
I
tenía.
don't know.
All right, so maybe I didn't tell the truth here, but I promise you this time when I'm talking about the accident, I'm really telling the truth here. So as it turns out, the company safety director, who you heard from a little earlier and we're about to hear from again, kind of had an idea that maybe this guy wasn't shooting straight with him. I want you to listen to this testimony and just see if you agree with what I was saying about that.
The other decision you
That was what caused the wreck, Lee.
Yes.
And have you made that decision?
With the limited knowledge and not being there, and I kind of put a little bit of credence into what gets said on the side of the road versus what you can, conjure up, 2 days later, which was, hey, the guy cut in front of us and we couldn't stop.
That's his own driver. He's talking about conjuring up a story. I thought he said that when I was there, but it was almost too good to be true. And sure enough, when I got the transcript back, that's what he said. So he tried to back away from it later, but basically what he's saying there is, I put more credence into what the driver was telling me by phone, and by the way, he spoke in English by phone, so I don't know why he couldn't speak in English when I was deposing him, but he talked to his owner, to his boss man in English. I put more credence into what he told me then 2 days later when he filled out our incident report and started talking about people cutting in front of him and all that. Conjure up, I thought that was a pretty good use of words there. I liked it anyway. They didn't like it. All right, so in this case, we showed you the duty. That's the company document. The breach of the duty was going against the company document and hiring the driver anyway. The causation we proved through our expert that's how the wreck happened. And then that leaves us with damages. All right, that's the fourth element in any case. In this case, unfortunately, had a ton of damages. That means our guy was hurt really bad. It was a rear impact wreck. This was an excellent plaintiff. I mean, he was wonderful. He had had the same job for 39 years. He drove a mail truck. He got up early every morning, worked late every night, worked 7 days a week when he had to. He didn't work for the federal government. He was a private contractor, but he was as good as gold. And by the way, he was uneducated. That was the only job he had had for 39 years. He was not trained to do anything else, and he could never do that job again. That's a lot of damages. He could never support his family again. So, some things that a jury gets to consider in Alabama under damages, there are two different kinds of damages. There are compensatory damages and punitive damages. Compensatory damages are meant to compensate the injured party. Punitive damages, we'll cover those first. They're toward the bottom of the screen there. We've all heard of punitive damages, and basically they're rare. That's what you need to know. They're rare in Alabama. That's really not the story you hear sometimes, but they're rare. There are two purposes. One is to punish the wrongdoer. So the jury in this case could have punished this trucking company for putting a driver like that on the road, or they could have sought to deter that kind of conduct from other trucking companies. So it's either to punish or to deter the conduct, or both. But back to compensatory damages, and basically, before we get to compensatory damages, punitive damages up to the discretion of the jury. It's pretty wide open what a jury will consider. Now, appellate courts will cut that down. Usually there's a ratio between compensatory damages and punitive damages that a court will allow to stand, but compensatory damages can be things like medical bills, lost wages, did the person have surgery, are there any bills that are still outstanding, were there any permanent injuries? In this case, unfortunately, there were. He had a neck surgery and a back surgery and could never really work again. He had scarring from his surgeries and from the wreck itself. Those can be considered by a jury. Future medical bills, and in this case, his physicians testified that he was going to need more surgeries down the road, and so a jury needs to consider those things too when they're making an award. Future lost wages, and then pain and suffering. That's another one that's kind of wide open for the jury's consideration. There is really two parts to that: physical pain or mental suffering. Physical pain or mental suffering. And so juries can consider all of those. And in this case, we helped them along a little bit. This was a medical exhibit that we used in the doctor's deposition. This case settled, by the way, just shortly before trial. But this diagram here showed the condition of both his neck and his back. Jurors, like the studies show, that if you want somebody to remember something, you show them and tell them, right, at the same time. That's how you get juries to remember things. And so we showed them that. They also heard in this case from an expert witness who testified that our client was 100% disabled vocationally, meaning that he was not able to work again. And she based that opinion, the expert did, on these things. Medical records. She reviewed every page of the medical records. She interviewed the doctors. She read the doctor's depositions. She actually tested our client also to see what he was capable of doing. Is he trainable in another kind of field? The doctor's testimony that he can't work, they considered our client's educational level. Was he able to go back to school maybe to get another job? And in this case, the answer was no. And those are some other things there that this expert considered in coming up with he was 100% disabled. And so we took that idea and put it in front of an economist expert. The economist said the total damages were $863,000. And that's just in economic sense. That doesn't consider pain and suffering. That is medical bills and lost wages and future lost wages and future medical expenses. That's what the economist was going to say at trial. And so, what do you think? Damages? We have those in this case? I think we did too, which is probably why the case never got in front of a jury, right? Both sides like to settle cases that are not favorable. And so what that means as a plaintiff's lawyer, if I have problems in my case, I want to settle it. If I'm a defense lawyer and I've got a driver like this and a boss man that says he's making up stories at the scene, I want to settle that one. So most cases do not get to trial. All right, so I think we got about a few minutes left for any follow-up questions. I have really enjoyed being with you tonight as always. Any follow-ups? Yes, ma'am.
I've always wondered why one doesn't get compensated for the time lost.
Mm-hmm.
The time of your life, where family has to take you to the doctor and to the hospital and all these wasted times of the whole family.
That's a great point. She says, I've always wondered why a plaintiff is not allowed to recover for all the time lost, not only from the plaintiff, but family members' lives taken to and from doctor's appointments. And even when you're together, sometimes you're in pain, and so it doesn't really count like normal family time because the time is spent in pain. That's a good point, and that kind of goes to that catch-all pain and suffering. A good plaintiff's lawyer will argue those things and say, jury, it's up to you, but here are some things to consider. He wasn't able to cook the Thanksgiving turkey like he always does. He's not able to rake the yard anymore. That's a great point. Yes, sir.
Is there any time between actual, like in this case, when the damage occurs, to when you have to file a case? Is it like 6 months, 1 year, 10 years?
He's asking basically for the statute of limitations. That's what that called. Is there a time limit? And in Alabama, yes. It depends on who you're suing, and this is very important. Generally, the rule is if you're suing a person or a company, you have 2 years from the date of the injury to either settle the case or file a lawsuit. 2 years. Now, if you are making a claim against a city or a county, those time limits are shortened. If you're making a claim against a city, you have 6 months. If you're making a claim against a county, you have 12 months. And if you file a day too late, you're out of court. That's a very harsh rule.
Is it not true that the statute would start from the date that you discover the injury rather than the date?
That is a great question. Her question was, is it not true that the statute would begin to run from the date of the discovery of the injury, not necessarily the date of when the wreck happened? That is not the law. The law is that it starts from the wreck. Now, there are some cases in Alabama, and I would not want to rely on any of this if I was the injured party. I'd want to go ahead and file within the 2 year. Some states have a discovery rule, but it's not in a personal injury situation. It deals with more of a fraud situation. That's something we didn't cover tonight, but that's another tort. Fraud, if you believed somebody was telling you the truth and you didn't discover until years later that they were not telling the truth, then sometimes you do have 2 years from the date of the discovery. But that's, again, the defendants try to get that thrown out in a heartbeat. And so it depends on which judge you get And it depends on what kind of mood the judge is the day it comes before him.
Are there ways to delay the case where somebody needs surgery, and you don't know whether the surgery is going to be successful, and maybe they can go back to work? How does that come into the 2-year rule? And would you ever want to delay the case outside of 2 years to find that answer?
All right, that's a good question. Are there ways to delay the case if, say, a person is about to have surgery and you don't know if the surgery is going to be successful? There are agreements that it's called a tolling agreement. It tolls the statute. It extends the statute. I'm way too paranoid as a lawyer to believe that somebody wouldn't try to back out of that later. That makes me nervous. I'd go ahead and file the suit. And look, in Alabama, if I file a case tomorrow, it'd be unusual if it gets to a trial before 2 years from then. So you'd have plenty of time, and that's one of the things you can request a continuance in the trial if you want the jury to hear exactly how the person recovered. But I've been told that's all the time we have, so I very much enjoyed being with you tonight. Thank you for having me. Thank you. Thank you.